Said that to bring a lawsuit is really to open yourself up, to reveal yourself. Well, I'm here to tell you that that goes both ways. That when a defendant, especially in a construction site accident, is sued, you get a whole lot of information about them, as well you should. Not only will you know their business structure, not only will you know a lot about their budget and their personnel and who was responsible, and of course, you'll use this within the framework of what the state and federal regulations are and what their contract that they've engaged in calls for. But not only will you learn a lot of very case-specific information and superimpose that on the legal framework that we have, if you will, that I just referred to, you can also learn about many of their players. What kind of OSHA course did their representative, who was responsible for safety, undertake? If it was the OSHA 30-hour course, what was on that syllabus? All this, of course, is available online, and you can ask at a deposition of this safety person on behalf of, who was designated on behalf of the general contractor, well, what specifically did he or she learn in the OSHA 30 course, or in the OSHA 10 course, or in any other continuing education classes he or she may have taken, or in any other certification classes he or she may have taken, or in any other project to which he or she has been involved. What did they know about the particular issue that has led to your client's accident? So this notion of opening up to discovery, that the plaintiff has opened up the person's background, but applies equally, because you get to know everything about the corporation and everything about the corporation's players, from what they learned, from what they spent, from what their prior work history is. And many of those different things, sort of like branches, may lead to the discovery of more information. At the end of the day, it's all about safety. At the end of the day, it's about the construction site proprietor, typically the general contractor and various subcontractors, if the facts are applicable. We'll take it in the case of the general contractor, did they make safety a priority? In fact, was it the highest priority? Do they agree that they should never needlessly endanger workers on the site or anyone who would be coming onto that site? Do they agree with their obligation, if it's the general contractor, to initiate and supervise and maintain safety? Do they agree with their obligation to create a site-specific safety analysis or a job hazard analysis? Will they agree what their duties are as a general contractor? Will they agree what the risks are if those duties are not followed in a very careful way? When you get a string of admissions to those propositions and principles, you go a long way to proving your construction site accident case. Thank you.